scared of my team, they know who I am. They rolling the dice, we win cause we plan. The things that they teach, don't know how to stand. I'm a wrist like a stage, they can't glance. You look like you wanna let go of stress. What's up? I thought so. Oh, I am the blueprint, if not, why you copy me?
You're rocking with the best.
I cannot
You're rocking with the best.
They rolling the dice, we win cause we plan. The things that they teach, don't know how to stand. I'm a wrist like a stage, they can't glance. You look like you wanna let go of stress. What's up? I thought so. Oh, I am the blueprint, if not, why you copy me, fam? What's up? I thought so. Okay, I cannot help that they copy. Hey, I am their dad, call me Poppy. Yo, they wish they created the set. Yes, they on my D like a jockey. When it comes to the print, I'm the blue. Who? Every complaint, draft is smooth. Supreme Elite team be the ones. Yo, I created my own school. Facts. I came from the trenches. I came from riding them benches. To proving my case with exhibits. My craft is exquisite. I find where they hiding them digits. The cancer that's not in remission. Hey, please pay attention. You can't recreate the five lenses. You can't duplicate what is written. You either gon' pay the tuition or pay for assistances, or pay the mistakes when you case it, dismiss them. I come with everything that's under the kitchen sink. I haven't slept in a week. They scared while I'm willing to compete. These scammers are devils and I keep them under my feet. Hey, they saying they win, I never take their prescription.
You're rocking with the best.
Check it. When I talk classes in session, professionals, even the tacos respect it. Show me a win, that's not a rejection. Tell me the truth without all the stretching. These gurus are boring and it's stretching. These students are dumb, desperate depression. Set you, yeah, I'm done with this lesson. Came from the streets, still I'm a step up. Run it up, running bands. They scared of my team, they know who I am. They rolling the dice, we win cause we plan. On the things that they teach, don't know how to stand. I'm a wrist like a stage, they can't glance. You look like you wanna let go of stress. I thought so. Oh, I am the blueprint, if not, why you copy me, fam? What's up? I thought so. Okay. New culture, he running this shit. Hey, like he came with a gun in this bitch. Black, and he double up wins back to back. Oh, like he ain't even done with this shit. Come to court like a dog off the leash. Dismantle the evidence, break down their claims, and he start from the top of the sheet right here. Whenever he taught, they retreat. He's a lead with his team, they supreme. He brings reality out of drink. Okay, they can't help but watch from the clouds. They trying to words and the memes. Alibi with the feds. You fuck with alibi, you be in the feds. Lawful lovey, still a rookie. Can't stand on the shit that they saying. Hey, he beat his case, he beat CAC.
You're rocking with the best.
Let me try to give a break. Attention they didn't wanna pay. Made them max sit, they on case. Get the fuck out his face. The new culture ain't wanna play. The new culture running this shit. The new culture with debate. Anyone who think they running this shit, he take your docs and expose that shit. Gon' be acting like you never sold that shit. They copy his drip like he sold that shit. Ain't no guessing with him, gotta know that shit. Hey, you gotta know that shit.
Biggest hurdles that all of you jurisdiction people going to get over, can't get around.
Buckle up, Buttercup. But you sit the down. You guys are so retarded because you're a failure, because you're a loser, and you don't understand what jurisdiction is.
The biggest hurdles that all of you jurisdiction people going to get over, can't get around.
Buckle up, Buttercup. But you sit the down. You guys are so retarded because you're a failure, because you're a loser, and you don't understand what jurisdiction is. Listen and learn. You might be able to scam some people if you actually knew what the you were talking about, you fraudster. There's three basic things: land, air, water, law.
Emotional, damn it!
Land is the law of the land, the common law. Air, ecclesiastical, canon law, trust law. And water, admiralty maritime law.
Oh boy.
The law of contracts. Are you government? No, they're not, because Title 28, Section 3002, subsection 15A and B and C says the United States is a federal corporation.
Erroneous! Erroneous!
They're not government. They don't have jurisdiction. Two, Clearfield Trust Company versus United States. 318 U.S. 363. When governments use
Baby, spit it out. Come on. Time is money.
securities instruments, Federal Reserve notes, checks and money, they descend to the level of a mere private corporation. And then, according to Cook versus United States and U.S. Guaranty Trust Company versus United States, because none of you f***ers have read that. They must be the holder in due course of a contract or other commercial agreement between it and the one upon whom demands for specific performances are made.
So, TikTok's favorite self-proclaimed legal mentor, Antonio Luis Freire, just stitched the New Culture Empire's video claiming he was wrong about state court jurisdiction under the 10th Amendment. He's out here lecturing on admiralty law like he's Captain Jack Sparrow, completely ignoring the fact that maritime statutes only apply to actual navigable waters and seas. He wanted his attention just like Ellis Raspberry did. So the New Culture is going to give it to him. Antonio acts like a private attorney general and supreme authority on case law online. But let's look at his actual record in real life. In Freire versus Sullivan, he sued real judges because they wouldn't let him practice law without a license. The federal court completely threw it out, labeling his arguments unrelated ramblings and a meritless legal theory. In 2022, he tried to sue a Nevada police department inside a California court, thrown out for basic jurisdictional failure. Then in 2023, Freire versus Spirit Bus Company, dismissed because he failed to prosecute his own case. In fact, federal judges routinely pre-screen his lawsuits out of existence under Section 1915 for being legally frivolous. Imagine trying to play mentor on TikTok when real-life judges keep throwing your filings into the paper shredder. Go argue with the courts that dismissed you. Antonio, you tried the wrong one. Class dismissed. And just like Ellis Raspberry, Honey V, Antonio Freire, and many online court sovereign citizen gurus, they always have the answers online, but in real life, their cases are dismissed before they can ever get started. Antonio Luis Freire, play with something safe. The New Culture Empire isn't one of them. Now stay tuned as we will go over just how Antonio's teachings and understanding plays out in court.
It's get on my team, they know who I am. They rolling the dice, we win cause we plan. The things that they teach don't know how to stand. I'm a wrist like a stage, they can't glance. You look like you wanna let go.
Uh-oh. Uh-oh. We have another one. This is going to be called the Summer of the Smoke. Because if you want smoke,
You're rocking with the best.
you better recognize who you want smoke with. I'm the equal opportunity smoke giver. Now, this guy, he noticed that my video on TikTok had over 6,000 views, 133 comments, almost 200 likes, over 100 comments. And these jurisdiction people came out of the woodworks. They came out of the woodworks. And he wants to make a hit piece, all types of ad hominem attacks, all types of things of that nature. But Antonio Luis Freire, just like the rest of them, The ones who does this are the ones who are selling the same things. They are selling the same things in which the courts have already rejected. So he wants to talk about court and legal and land, air, sea. And what we're going to do is we're going to break down exactly what happens when people like him step into a courtroom. Because we're not going to sit here and lie. He saw a black man getting a lot of likes and comments. And he didn't like the fact that a black man was speaking on something that he probably thinks, you know. So before we do it, let's go here.
All of you jurisdiction people.
This is the video that got pretty much kind of put me on the map in TikTok. That got over 365 likes. That got a bunch of people's panties in a brunch. So this is what I'm saying.
The biggest hurdles that all of you jurisdiction people going to get over, can't get around, is that the courts have jurisdiction. Number one, based on the 10th Amendment.
And I got sidetracked and went into admiralty, but the other one is the state constitution. And in this video, as you can see, Article 1, Section 8, you see that supersedes the state law. Article 1, Section 8 of the Constitution describes specific powers which belong to the federal government. These powers are referred to as the enumerated powers. The 10th Amendment reserves powers to the states as long as those powers are not delegated to the federal government. Among other powers, this includes creating school systems, overseeing state courts, creating public safety systems, such as the DMV, such as the driving laws, such as criminal statutes, managing business and trade within the state, and managing local government, right? Now, the conferred powers that are shared by both the federal government and the state government, this includes the power to tax. That's why some states you got state taxes and you got federal taxes, build roads and create lower courts, conferred powers.
So all this common law court or admiralty courts. Admiralty courts are for crimes committed at the seas, the naval.
Right there. That is the part where their panties went into a bunch. Now let's look down at the side. Look.
The biggest hurdles that all of you can't get around is that the courts have jurisdiction. Number one, based on the 10th Amendment. So all this common law court or admiralty courts. Admiralty courts are for crimes committed at the seas.
Right there. Now, if you look at these comments, you got Lux Private Media showing case law. You got him down here showing case law that support what I'm saying. Lux saying you're 100% right. Those amazing people don't want to hear that, though. They love law mythology. And you notice how you get a comment here, wrong. But I said, y'all notice how y'all come in and say wrong, but never, I went to court and got my own case thrown out. Here's the case file. Order of dismissals to prove it. So Thomas, you're wrong. I just had it live on this, and they will identify with it so hard that they will come and say wrong just because they believe in it so strongly. If the court rules say something different from what they believe, the courts are wrong in their eyes. So look at this. The courts are built in flood plans so they could claim admiralty maritime jurisdiction. U.S. Navy did all flood plan zonings of the U.S. courts. Look at this. You have no business in court. The mailbox is your court. Look at this. Sovereign citizen through and through. Look at this. The secret of the special maritime jurisdiction of the United States exposed, revealing the most repugnant fraud ever perpetrated on the people of the United States of America. A brief dissertation exposing. Look at the last name. L. Bay. Look at the dude, Sunday Anderson X. But look at this. When I'm responding to, okay, show me that you've won. The court does not have jurisdiction because the courts don't own the land. I just sued 2 judges for lack of jurisdiction. Did he ever show the outcome of those suits? No. This is all they do. Only common law agrees. If you was it, look at the comments, y'all. It went on and on. Boy, they got so hot. I mean, you could just go in the video, watch on and on. But one of the things that they all overlooked is it clearly has the statute, which I'm referencing. The law of admiralty, admiralty law or maritime law refers to a body of law relating to the seas and navigable bodies of water, not you were birthed at the sea, not your ocean through your mom's vessel and you docked on the ship. No. A sea, not the creek in the back of your apartment complex or the back of your house. A navigable, I mean, you can drive a boat, an ocean, like the Pacific Ocean, those in canals. Admiralty law extends to incidents that occur on the oceans, lakes, rivers, canals, and wetlands. Now, they're going to take that and try to fit courts inside that, because clearly the context, which right here, everybody can see, has nothing to do with your everyday state courts. However, admiralty law does not extend to bodies of water that are not navigable and not used in interstate commerce, such as what I just say, a creek, pond, or stream. Admiralty laws covers, among other activities, maritime commerce, which is shipping of goods, import, export, navigation on bodies of water, towage, maritime liens, piracy, recreational boating, hiring of officers and crews, and insuring of naval vessels. Article 3, Section 2 of the Constitution grants the federal judiciary original jurisdiction over maritime law. Cases that arise under maritime law are heard by an admiralty court, which in the United States are the United States District Court or within territorial jurisdiction. Admiralty courts may apply state law, but will not do so if applying state law undermines the uniformity of maritime law. So no case law that you're going to traffic tickets, foreclosures, none of that has anything to do with maritime or admiralty law. Where did I lie? Because this is going to be all about another belief system. And Antonio Luis Freire, you are in no position to speak on anything. You suck at court. You have not won, just like Ellis Raspberry. You have all these talking opinions, but never can show that you won on your arguments. Come on.
Naval, the ocean. So take that out of your driving tickets, consumer law, being sued, civil court, criminal court. Take admiralty and throw it in the trash. I know your mindset and your belief don't want to do it, but the reality is, put it there. It doesn't apply unless you're on the seat. Out of your driving tickets, consumer law, being sued. So take that out.
Right here. This is the part where their belief systems and mindset ran right into this smack, right into the reality. You see these comments? You should go back and read the comments. It is absurdity in these comments. But this is the part where they really hate it, right here.
Of your driving tickets, consumer law, the ocean. So take that out of your driving tickets, consumer law, being sued, civil court, criminal court. Take admiralty and throw it in the trash. I know your mindset and your belief don't want to do it, but the reality is, put it there. It doesn't apply unless you're on the seat.
That is the part where they went, oh my, all hell broke loose. You mean what? Out of criminal court, civil court? So let's get to what Mr. Lawful Patriot really had to say. Because I gave you a piece of it, but let's see what he really, I don't know which one is his, okay, so let me go back to this one. Here we go, right here. This is look. So let's watch this. We're going to watch it in its entirety. We're going to watch it in its entirety. And then when we're done with this, we're going to go to see, once again, just how does it play out when they try to apply what they're telling you online in their own situations. Let's go.
The biggest hurdles that all of you jurisdiction people going to get over, can't get around.
Buckle up, Buttercup. But you
notice how he didn't want to see, he stopped it right when the statue came out. You notice how he stopped it right there? Come on.
bitch, sit the fuck down. You guys are so retarded because you're a failure, because you're a loser, a schmuck.
Oh, I am? I'm a failure, a loser, and schmuck. Bro, I probably give my daughter more money than you make in a month. Like, you don't win nothing. By your own logic, based on the court pleadings and filings, you're the only loser because you can't show a win. 80 cases beaten, challenging jurisdiction, 80 plus cases. Okay, so we're going to pull up a few of your cases.
And you don't understand what jurisdiction is? Shut the fuck up and listen and learn. You might be able to scam some people if you actually knew what the fuck you were talking about, you frauds.
That was funny right there.
There's three basic things: land, air, water.
Off the break, typical sovereign citizen. Every sovereign citizen for the past 30 years say that. There's nothing in the court rules and procedures that has land, air, water. That does not make up the law. Land, air, water does not make up the law. So this is another opinion, a belief system. Now, you got this person saying you just got to love Antonio. He puts it out there like it is. How when he's losing? Cops are required to calm down, brother. Be nice to people. Calm down. There's only one common law. That's English common law. Guess what I put? Show the 80 cases. I put show the 80 cases. Nope. He doesn't even say anything. And then look what I did. I posted his case. Look, the recommendation. I posted his case. Did anybody respond? Nope. Silent. I posted another one. Right? Right? So look at all this. Look at all this. Laughing. Oh, it's funny, huh? El Negro Nueve, 100, 100, 100, 100. Okay, let's see how 100 you is after we break down what he found. And this shows the mindset of these people. Let's go.
Law. Land is the law of the land, the common law.
Right there. That's it. This is a belief system. They're making up their own acronyms.
Air, ecclesiastical, canon law, trust law.
Already showed case laws regarding that. People use that in court forever. The presumptions, ecclesiastical. What is ecclesiastical? Ecclesiastical law have to do with everyday court rules of procedure, civil rules of procedure, criminal rules of procedure, rules of evidence. Nothing. Absolutely nothing. They call that sovereign citizen.
And water, admiralty maritime law, the law of contracts.
Nope, not just the law of contracts. It deals with the shipping goods, navigable waters, not just contracts. They think admiralty law only deals with contracts. Absolutely not.
Now, if you go and look at those and you go, are you government? No, they're not, because Title 28, Section 3002, subsection 15A and B and C says the United States is a federal corporation. Fuckhead, they're not government. They don't have jurisdiction.
Look, see, here's the thing right here. Forever and ever, this is typical sovereign citizen rhetoric. Everything he said was wrong. Nothing. Now look at here. Look at this chapter. Look at this chapter. Look at this chapter 176. What does chapter 176 deal with? What does chapter 176 deal with? Huh? Federal debt collection procedure. Does it say anything dealing with the country as a whole? Is the whole country a federal government? As in the United States of America itself a federal government? Applicability. And they don't read none of this, by the way. They just go to that one definition because they heard it passed around in documents and papers forever. They don't ever read it. They don't ever read it now. They don't ever read it. Except as provided in subsection B, the chapters provide the exclusive civil procedures for the United States to recover a judgment on a debt. What's the context here? A debt. You owe a debt to the United States. So these are the procedures that they have to follow to recover a debt that you owe them. Small Business Administration, IRS debt. You got a loan, a small business loan from them. You got a loan, whatever. Student loan. Or to obtain before judgment on a claim for a debt, meaning a civil court, a remedy in connection with such claim. To the extent that another federal law specifies procedures for recovering on a claim or a judgment for a debt arising under such law, those procedures shall apply to such claim or judgment to the extent those procedures are inconsistent with this chapter. This chapter should not apply with respect to an amount owing that is not a debt, or to a claim for an amount owing that is not a debt. And this was last updated November 29th, 1990. So, let's see if we have it here. I just want to see. Okay, so it was in here. So this was under the Crime Control Act of 1990. So this clause, remember I told you what the government, I told you what the federal government would do? The federal government, when they pass a law, they'll have extra clauses inside the real act. You get what I'm saying? So they'll have a whole big old act, but they'll have certain clauses in there that provides for this, provides for this. This was inside that. Do you think they ever clicked on here to actually read the whole thing to get the 100% context? I don't know why it keeps taking me there, but in any event, I was going to pull up the chapter. So this is dealing with debts owed to the United States. Now, which 3002, what does a debt means? A debt meaning that is amount that's owing to the United States on an account of a direct loan or loan insured or guaranteed by the United States, or amount owing to the United States on account of a fee, duty, lease, rent, service, sale of real or personal property, overpayment, fine, assessment, penalty, restitution, damages, interest, tax, bail bond forfeiture, reimbursement, recovery of a cost incurred by the United States or other sources of indebtedness to the United States. But that is not owing under the terms of a contract originally entered into by only persons other than the United States. So, nothing here is talking about anything outside of a debt based on these subsections right here. Right? So when you click on the definition of United States, the United States means a federal corporation of the United States. That can be their government, Fannie Mae, Freddie Mac, student loan, I mean, all those. That it could be any one of the corporations that you owe a debt to them. Not a United States means a federal corporation, now meaning the United States government is a corporation, because the context of this statute is a debt collection. Right here, recovery judgment on a debt. That's the context. Remember, context is a moving part. So when it says United States, definition means a corporation that's owned and ran by the United States government, an agency, SBA, a department, Internal Revenue Service, the commission, board, or other entity of the United States. Meaning, this right there, all of their corporate entities and agencies that you contracted with, that you owe a debt, or an instrumentality of the United States. These are your Navy Federals of the world, Wells Fargos, etc., etc., etc. You see? Is there anything here that deals with the United States? And look at this: disposable earnings, garnishment, court judgment. Persons includes a natural person, a corporation, a partnership, an unincorporated association, a trust, or an estate, or any public or private entity, including a state or local government or Indian tribe. Prejudgment remedy, property. This is what they're talking about. So, what did you say again?
Government, they don't have. United States is a federal, and B and C. So the United States is a federal corporation. Fuckhead, they're not government. They're not, because Title 28, Section 3002, subsection 15A and B and C. So the United States is a federal corporation.
You see that? You see how they took that one word, federal corporation, because their mindset wanted it to be that, and never stopped to get the full context to truly understand if it actually was a corporation in the sense of the country itself being one big corporation, or maybe they're talking about in the context of a debt collection. If I owe an agency, a corporation, a department, a commission, a board, or other entity or instrumentality of the United States. You see the difference?
Fuckhead, they're not government. They don't have jurisdiction.
Look at him. Look at him. He thinks he is doing, he thinks he is tearing me a new one, don't he? Pause. Oh, he think he doing this big one.
Fucking retards.
Right, the retards. Right. Come on.
2, Clearfield Trust Company versus United States.
I'm glad you said that. I'm glad you said that. Clearfield Trust Company versus United States. I'm glad you said that. I'm so glad you said that. Oh, I'm so glad you said that. Clearfield Trust Company versus U.S. Is this case cited by sovereign citizens? Is it? Yes, Clearfield Trust Company is heavily cited by sovereign citizen. Is one of the most frequent misuse cases in their entire movement. In real law, Clearfield Trust is a foundational Supreme Court case about civil procedure and commercial paper. It established that when the federal government issues a check, a federal common law, not varying state laws, governs its rights and duties what relates to the check. However, sovereign citizens have twisted a single concept from the case into a massive pseudo-legal conspiracy theory known as the Clearfield Doctrine. Sovereign citizens used the case to make several structurally flawed arguments in court. The myth: they claim Clearfield provides that because the U.S. government uses private commercial paper, Federal Reserve notes / dollars, the government has stripped itself of its sovereignty and descended to the level of a mere private corporation. That's what they're saying. The real law. The Supreme Court only said that when the government deals in commercial paper, its commercial rights, like suing a bank over enforced checks, are evaluated similarly to a private actor's rights. It did not strip the government of its sovereign powers, criminal jurisdiction, or statutory authority. The myth. They argue that because the government is just a corporation, a court, police officer, or government agency cannot enforce any law or statute against an individual unless they can produce a signed private commercial contract with that specific person. The real law. Government's authority over citizens flows from the U.S. Constitution and statutory law, not private contract law. You do not need to sign a contract with the government to be bound by criminal and traffic laws. This is correct. So the government under the Clearfield Doctrine is a private and entity. And the case, this person used it too. This person used it too. Look. This person used, look, sovereign citizen stuff all through here. Look. It's case law where they cited it. Look, this person cited it too. You see? The link to the case where they cited it. Look at this case. This is where he cited it here. 29. I bet you the judge pretty much destroyed him. Look. Where they, the Clearfield Doctrine. Look at all these. United States versus Hakeem. The defendant clears to cite the Clearfield Doctrine. Cases so-called sovereign citizen alleged against the courts have repeatedly rejected as no more than gibberish. The objections are rife with gibberish, sometimes associated with an alleged sovereign citizen. Look, he cited the Clearfield Doctrine in this case. He cited it. This is what he cited. This is not Antonio, but this is someone else. Look, this is someone else who has cited the Clearfield Doctrine. Now, it's 29 pages. I'm not going to read this. I'm going to actually read Antonio's cases. But if you look, just look at the judges. Just look at 29 pages of scalping. They get scalped by the court every time. Now, let me see if I can find the Clearfield Doctrine reference in this case. Because he used it. He used the Clearfield Doctrine too. I don't know exactly where he cited it, but let me just scroll down a little bit longer just to see if I can see where he actually. Here we go. Here we go. Defendant appears to cite the Clearfield Doctrine in order to demonstrate that the United States lacks jurisdiction over him. Reliance on this doctrine is another frivolous claims raised by proponents of the sovereign citizen movement who believe they're not subject to federal or state statutes or proceedings and place special significance on commercial law, which claims have been uniformly rejected by the courts. In Clearfield Trust Company versus United States, well, didn't we just read that with the Google? We just go to AI mode. Wanna know why? Because we could just summarize it. We could just summarize the case. But the United States issued a check through the Federal Reserve Bank of Philadelphia in the amount of $24.20 for services rendered to the Works Progress Administration. The intended recipient never received the check. The check was inexplicably received by an unknown person who misrepresented himself and endorsed the check to JCPenney Company in exchange for merchandise and money. The intended recipient never authorized the endorsement, nor did he participate in the proceeds of the check. Penny endorsed a check over to Clearfield Trust Company, which accepted it and endorsed it, paid to the order of Federal Reserve Bank of Philadelphia. Clearfield Trust collected the check from the United States through the Federal Reserve Bank of Philadelphia and paid the full amount, therefore, to J.C. Penney. So the United States brought an action against Clearfield Trust to recover the amount of checks on the express guarantee of prior endorsements made by Clearfield Trust. The district court held that the rights of the parties were to be determined by the law of Pennsylvania, and since that the United States unreasonably delayed in giving notice of the forgery to Clearfield, it was barred for recovery. The Court of Appeals reversed, and the Supreme Court affirmed and stated that the rights and duties of the United States on commercial paper which it issues are governed by federal rather than local law. That is the context of the Clearfield Doctrine. So it's governed under federal law if they issue a federal check or a federal T-bill. Any instrument that they issue is going to be governed under federal law and not the state law. That's what Clearfield is saying. What are you saying again? What'd you say? Uh-huh. Uh-huh. Think about it. No, it's not what it said. It said when the government issues checks. That's what they said. When the government issues a check. The context of that was a check that was issued. You said security instruments? No, a check. Simple check. I mean, I'm not going to split hairs. Yeah, it could be the instrument. Let's say they're instruments that they issue. I'm not going to be petty. I'm not going to be petty and split hairs. I'm not going to be petty and split hairs. But yeah, let's go.
Federal Reserve notes,
Okay.
checks, and
Yeah.
bullshit money.
Okay. All right. I agree.
They descend to the level of a mere private corporation. And then
Hold on. You said they do. Oh, so the mere fact that they issue a check, they descend to the level of a mere private corporation. Let me make sure I got that right. I want to make sure I got it right. Give me 1 second. Let me go back and make sure I got it right.
descend to the level reserve notes, checks, and bullshit money. They descend to the level of a mere private corporation.
Damn, you got the sovereign citizen fucking program wording down pat. What does it say here? The myth. What does it say here? They claim Clearfield proves that because the United States government uses private commercial paper, Federal Reserve notes, dollars, the government has stripped itself of its sovereignty and descended to the level of a mere private corporation. Damn. You're saying everything that was you right out the sovereign citizen playbook.
To the level of a mere private corporation. And
wow. I mean, he got it word for word. Sheesh.
then, according to Cook versus United States and U.S. Guarantee Trust.
Cook versus, you know what? U.S. Guaranteed Trust Company
versus United States. Because none of you fuckers have read that shit.
Okay. Well, let's read it now. Cook versus United States. Let's just read it. Let's just look it up now. Let's just look it up now. When sovereign citizens refer to a Cook case, they almost always misusing Cook versus Tate to argue that the U.S. government cannot tax them. Okay. So, what is it? U.S. guarantee. What did he say? U.S. guarantee versus United States? What did he say?
United States and U.S. Guarantee Trust Company versus United States.
U.S. guarantee. Trust Company versus United States. The ruling in the Supreme Court in U.S. Guaranteed Trust Company versus United States, 1938, of course, it's always these 1920, 1867 cases that they want to cite, is that the United States government does not escape state statutes of limitations when it sues on a claim acquired from a sovereign government. The court held that the original claim was already time barred while owned by the foreign government. The U.S. cannot revive it. The deposit in 1960, Imperial Russian government opened a bank account with Guaranteed Trust Company in New York. Following the 1917 revolution, the bank closed and offset the account against debt owed to them by the Russian government. The incoming Soviet government contested this. In 1933, the United States formally recognized the Soviet Union. As a part of a diplomatic Litvinov assignment, the Soviet Union assigned its claims remaining American bank deposits to the U.S. government. The U.S. government sued Guaranteed Trust Company to recover the funds, but the bank argued that the claim was dead under New York statutes of limitations. So this is based on the immunity, the time bar. State statute of limitations cannot run against domestic sovereign public because public policy protects public rights from the negligence of public officials. However, this immunity does not apply to foreign sovereigns suing in American courts. So basically, if it was the government that sued originally, then yes. But since it was a foreign government's debt first, the statute's limitations have run out. So since there was negligence, the foreign government did not come under the same protection, right? So because the Soviet Union was bound by New York statute of limitations, so all y'all want to be foreign. I'm not United States, I'm foreign. You're losing a lot of your protections. Because the Soviet Union was bound by New York statute of limitations, the time to sue had already run out before 1933. When the Soviet government assigned the claim to the United States, the U.S. only acquired the rights the Soviet Union actually possessed, meaning it inherited a claim that was already legally dead. So none of the cases he's citing in this rambling has anything to do.
And then according to Cook versus United States and U.S. Guaranteed Trust Company versus United States, because none of you fuckers have read that shit.
Look at that. None of you fuckers have read that shit. It would be wasting our time. That's why. Think about it.
They must be the holder in due course of a contract or other commercial agreement between it and the one upon whom demands for specific performances are made.
No. Guaranteed Trust Company was statute of limitations because they inherited foreign debt. And Soviet Union was bound by New York State statute of limitations. Had nothing to do with what you're saying. I told you, people like him, I'm telling you, every time they cite a case and you actually dig into the elements of the case never says what they tells you it says. It never does. Waffle House. That's what you look like, a waffle. Look at that. Think about it.
And then, if it's a warrant, do they have a warrant for your arrest? Really, Judge? Please show me such. According to Mincy versus Arizona, it must be signed by a neutral and detached judge.
You are Mincy versus Arizona. Oh my gosh. Mincy versus Arizona. And they're always going to have you cite cases that are outside of your jurisdiction. In many cases. You are referring to the landmark Supreme Court case Mincy versus Arizona. It is one of the most important Fourth Amendment cases regarding police search and seizure rules. The Supreme Court ruled that there is no murder scene exception to the warrant requirement, meaning police cannot conduct an extensive multi-day search of a home without a warrant simply because a homicide occurred there. What did they do? Don't they say, hey, if you're either going to let us in now or we're going to wait to get the warrant? So they're going to go get the warrant. If a homicide occurred inside of a home, They're going to clear the scene. They're going to clear the scene. Get the warrant over the phone. They're going to get that bitch faxed. And then they'll come back with a warrant to search. Of course. So this is irrelevant what you're talking about.
It can't be signed by the same judge who's threatening you with contempt of court.
Hold on. That's not what it says. This has nothing to do with it. The case rose from an undercover drug raid apartment on Rufus Mincy. During a shootout, an undercover narcotics officer was tragically killed and Mincy was wounded. After the shooting stopped, medical personnel arrived. Homicide detectives arrived. They took control of the apartment and conducted an exhaustive 4-day warrantless search. Open drawers, whatever. Justice Potter wrote in the majority opinion, laying down 2 major legal precedents. No murder scene exception. The state of Arizona argued that a homicide scene should not be an automatic exception to the 4th Amendment warrant requirement. It looks like our constitutional rights are being protected there. I thought they're trampling over the constitutional rights. What's up, y'all? What's up? What's up? What's up? What's up? TikTok, YouTube, what's up? This. Don't worry. This is just another scalping. Just another scalping of Lawful Patriot. Another scalping. Didn't even got to dig deep to scalp them. I told you, these sovereign citizens, it's so easy to scalp them. All you got to do is just let them, videos like this, just let them talk. Just let them talk. Get it all out. Then we going to come back and fact check you word for word, claim for claim. Has he stated anything logical yet? Do you think this is the man who is actually going to win his cases in court? What do you think is going to reveal when we get into his cases? What do you think is going to pop up? What do you think is going to pop up? Wins, dismissals? Well, let's see. So basically, they were saying in actual law, Mincy is taught to everyday law enforcement officers in America to ensure they secure proper warrants during major crime scene investigations. Mincy is taught to make sure the protections under the Constitutions, the 4th Amendment, are adhered to. That's what I'm saying. They're not unilaterally running around violating your constitutional rights every day. Every time I hear these people on the panel, they violated my 4th Amendment. No, they're not. They're not. Just because you don't agree with the law and you don't like what they're doing doesn't mean they're violating your rights. They are taught to every law enforcement officer in America to ensure proper warrants during it. Right there. They talk about this. Blue to gold. There you go. There you go. There you go. It's the link. Right? So, however, much like Clearfield Trust, Cook versus Tate, the 2 things that he just cited, sovereign citizen misinterpreted cases, sovereign citizens frequently misuse Mincy versus Arizona court. They will quote lines from it about the sanctity of the home and private rights to argue that any police interaction inside a home or even standard code enforcement visits are entirely illegal unless the officer has a specific type of warrant they deem valid. That's true. If they produce a warrant, they're going to ask for oath of office. If they produce the oath of office, they're going to ask for the bond. If they produce the bond, they're going to ask for their certificate of citizenship. They produce the certificate of citizenship. They're just going to keep asking and asking. It's never one thing that they require. It's just like when they ask the question, Your Honor, is this a common law court, criminal court, or amity court? They're not asking if it's that because they really want to know, because as soon as the judge says, no, this is a criminal court, they always respond, well, under the Constitution, there's only 2 types of jurisdiction, common law, amity. So they never ask questions from a legit standpoint. They ask questions to see if they're going to get the answer they want to hear. And then when they get the answer they don't want to hear, they tend to school the judge on what type of jurisdiction it is. But they're at what type of court this is. I need to know. None of what they do it's all disingenuous. In reality, Mincy simply requires police to pause and get a warrant once an emergency context ends. So what are you saying again?
According to Mincy versus Arizona, it must be signed by a neutral and detached judge.
It has nothing to do with that. It has nothing. Basically, Mincy is basically saying you can't conduct a search in a home just because a homicide just took place there. You can secure the scene for officer safety, then you have to step back out and wait to get the warrant before you could start searching. It has nothing to do with a mutual, because in their eyes, no judge is mutual. No judge. They're going to contest anything. They always say, I want it done like this the right way. But when it's done like that, they still have a problem with it if it's not giving them what they want. Look at this man.
It can't be signed by the same judge who's threatening you with contempt of court.
That has nothing to do with the case.
Then, State versus Pollock, a Minnesota Supreme Court decision, State Supreme Court, and all the judges are bound by these because of Article 4, Section 1, full faith and credit shall be given. State Supreme Court versus Pollock, a Minnesota court. Then, State versus Pollock, a Minnesota Supreme Court decision.
So why is he jumping to all these different states? Why is he jumping? Why is he jumping to Minnesota? Huh? Why are you jumping all these? That's the state Supreme Court. So it governs the holdings in that state. Not in Virginia. You're most likely referring to State versus Pollock, a Minnesota Supreme Court decision that is highly popular among sovereign citizens and constitutional patriots. Well, what is his name? Lawful Patriot. Yo, fucking the AI mode, just on Google search, they're just scalping all these goddamn, every case. Like other cases in their arsenal, sovereign citizens completely twist the actual legal holding of Pollock to try to get out of traffic violations, misdemeanor charges, or vehicle impoundments. In 1967, James Pollock was ticketed for a traffic violation in Minnesota. At the time, Minnesota state statutes allowed a local court clerk, rather than a judge, to sign off on a formal criminal complaint and execute their arrest warrant. Pollock's lawyer argued that this practice violated the Fourth Amendment. The Supreme Court agreed with Pollock. It ruled that under the Fourth and 14th Amendments, a court clerk cannot determine probable cause or issue a warrant. And I agree. The power belongs strictly to a neutral and detached magistrate, a judge, who must independently review the facts before a citizen can be hauled into court. So the context of this case was a court clerk signed off on the warrant instead of a judge. Simple context. Sovereign citizens used this case to build a major pseudo-legal defense when dealing with traffic tickets. The myth, they claim State versus Pollock means that a standard traffic ticket issued by a police officer on the side of the road is completely illegal and void because it was not signed by a judge. You see how they take the little and twist it? That has two different things. The police are well within their powers to issue a traffic ticket. They argue that without a judge's pre-signed warrant, the police officer has no jurisdiction to pull them over and hand them a ticket. The real law. Pollock has absolutely nothing to do with roadside traffic stop or an officer handing you a ticket. A traffic citation is simply a notice ordering you to appear in court. Pollock only dictated what happens after a ticket is written. If the state wants to file formal charges or issue an arrest warrant because you failed to show up, a judge must sign the paperwork, not administrative office clerk. If a sovereign citizen, and you can tell they get shut down. Yeah, they get shut down. So I want you to say it again.
And all the judges are bound by. Then, State versus Pollock, a Minnesota Supreme Court decision, State Supreme Court. And all the judges are bound by these because of Article 4, Section 1. Full faith and credit shall be given in every state to each state's judicial acts, records, and proceedings.
What did he say have to do with that case? What did he say out of his mouth that had to do with that case? Y'all, they don't ever read the cases or get the summary just to see what the case is about. Huh? What? What? Look at this. Look at it. Look at this. Look at the comments. Look at the comments. Look at the comments. Look at the comments. Huh? Look at this. He said nothing that had to do with the case. Yo, they can't even interpret case law correctly.
That means they have to obey other people's decisions. If they're Article 3 judicial courts.
Wrong. It just, that case means that a judge must sign off of a warrant or probable cause, not a clerk, because that was the practice in Minnesota, that the clerk usually sign off on it. Supreme Court said no, only a judge can. That's it. And you know that only that doesn't happen anymore. A judge is signing off on the warrant. Ask Ellis Raspberry on them orders. The judge is signing off on it. So you are wrong, Lawful Patriot. You're making, just like the rest of them, you are making it up as you go.
You're just fucking stupid, dude. Shut the fuck up.
Oh, shit.
You're harming so many people.
I'm harming so many people. Y'all hear this shit? Oh, man.
Do you give a fuck about anything besides yourself and your ego?
Ooh, that hurt my feelings. All I did was just scalp every single thing that you said. And somebody please share this with Lawful Patriot. I would love for him to come up here and explain all his assertions after we go over his case next.
Then, U.S. versus Hotel, the warrant or affidavit in support of the warrant must clearly, narrowly, and expressly name the triggering event.
Okay. What do you say? U.S. versus Hotel? Let's go. U.S. versus, I think, U.S. versus Hotel. I think, let me see, U.S. versus Hotel?
Narrowly and expressly. Then, U.S. versus Hotel, the warrant or affidavit in support of the warrant must clearly, narrowly, and expressly name the triggering event.
I'm going to venture out and say, I'm not even going to look that case up because I don't have that spelling of the name. But regardless, if you look up that case, I'm going to bet my bottom dollar that it's not going to say what he believes it says. Just like every other case he cited. Mincy, Clearfield, U.S. Guarantee. Every case he cited in here, I ain't read the hotel one, but I'm gonna add it in there anyway. Every single case he cited, it does not say what he think it's saying.
That means the affiant must name the probable cause or reasonable articulable suspicion. And if
That's what they do. That's what they do. It don't even if they got it down to the T, y'all still gonna say it's wrong because in reality, people like Antonio Luis Freire, y'all don't believe nothing applies to you. Nothing governs you. You don't got to follow no rules, no laws, no nothing. And they'll be violating your rights just because they held you accountable for violating the law.
if they don't have those, if they don't have A or B or C, they don't have no jurisdiction, bitch. And you can beat the case. And there's nothing they could fucking do about it.
And you can beat the case. 80 cases beaten, challenging jurisdiction, right? Okay.
Because that's their rules. That's their Supreme Court. That's their federal laws. But you're just fucking retarded, dude.
Right.
Shut the fuck up, please.
Right.
The biggest hurdles that all of you jurisdiction people going to get over.
Right. So let's get into it. Let's get into it. Let's get into it. Oh, this is about to be good.
You're rocking with the best. You're rocking with the best.
Uh-oh.
You're rocking with the best.
Uh-oh. Uh-oh. Yeah. Hold on. First violation. Less severe results of the warning. So basically, TikTok has the next violation will strike in the strike. You complete officer fire training. You can complete. So TikTok has your access is gonna try to vote together be restored on 25th. So TikTok has removed my access just for reviewing what he was saying about me. Spreading conspiracy. This motherfucker. Look at it. So they restricted my TikTok access by me reviewing someone that was reviewing my video. And I get struck for all the things. I think they must have thought that I'm playing the video that he put out. President Hate Group, they think that this is what someone said about me. Wow. So they gave me a warning and removed my access, which is crazy. Look, I can't even go. I don't know if I can go live. I can't go live and get on TikTok to, what's today? July 25th. July 25th. What's today? The 22nd? 3 days. For going over So hold on, we about to finish because I'm gonna put it on record anyway, so I can record it. We're gonna put it on record so I can record it. We're gonna put it on record anyway, so I can just have it recorded on the record. And it looks like, wow. 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 And guess what? All I did was respond. All I did was respond. That's all I did. Taking his words and going by it. And I get hit with the, what you call it. Well, guess what? Guess what? I'm still gonna go. I'm still gonna go. I'm still gonna go. Wow. All it takes is someone else. So let me make sure I got this recording. Hold on, y'all. Let me make sure I got it recorded so I can record. Make sure I got the recording up. Let me get my phone out so I can record. I can record this scalpel. All right. So since TikTok has restricted my live access for the next 3 days, still doesn't stop the actual recording. So this matter involves plaintiff Antonio Luis Ferry's civil rights action against Diana Sullivan, Judge Melissa Saragosa, the State Bar of Nevada, the Regional Justice Center. Before the court is plaintiff's Antonio Luis Ferry's application to proceed a form of pauperous. Just like the rest of the sovereign citizens, they don't ever want to pay for anything. And complaint, Mr. Ferry's application to proceed a form of pauperous is granted for the reasons stated below. However, Mr. Ferry's complaint should be dismissed with prejudice. That's even worse. Dismissed with prejudice. Mr. Ferry brings this case pro se and is seeking to appear in form of pauperous pursuant to 28 U.S.C. Section 1915. Under Section 1914.4, a filing fee is required to commence a civil action in federal court. The court may authorize the commencement of the action without prepayment of fees, costs, or security, therefore, by a person who submits an affidavit that includes a statement showing the person is unable to pay such costs. They never want to pay their filing fees. The standard governing informal pauperous eligibility under Section 1915A is unable to pay such fees or give security, therefore. Determination of what constitutes unable to pay or give security, whether to allow plaintiff to proceed. Yeah. Here, Mr. Ferry's affidavit states he has a monthly income of $1,000. Damn! The affidavit also states that Mr. Ferry's recently changed jobs and is having difficulty making bills. It's always those type of sovereign citizens too, who's not benefiting financially from their mindset, economic. It's always those ones that's in that position that has the most to say. I get it. Mr. Ferry has no money in the bank. Mr. Ferry's application to proceed is granted. Upon granting the informal pauperous, a court must screen a complaint pursuant to Section 1915E. Federal courts have the authority to dismiss a case if the action is frivolous or malicious, fails to state a claim upon which relief may be granted, or seeks monetary relief from a defendant who is immune from such relief. A complaint or portion thereof should be dismissed for failure to state a claim upon which relief may be granted, if it appears beyond a doubt that the plaintiff can prove no set of facts in support of his claims that will entitle him to relief. See Buckeye versus Los Angeles. A complaint is frivolous within the meaning of subsection E, 1915, if it lacks an arguable basis either in law or in fact, Cato versus United States, or is premised on a non-existent legal interest or delusional factual scenario. And a finding of factual frivolousness is appropriate when the facts alleged rise to the level of irrational or wholly incredible, whether or not there are judicially noticeable facts available to contradict them. See Fradis versus the Land, holding that dismissal is appropriate for a claim based on an indisputably meritless legal theory. Let's go here. Mr. Fury purports to bring claims against various state governmental entities and officers for preventing him from practicing law on behalf of himself and others. In particular, Mr. Fury's claims stem from an attempt to defend a friend contracted client in state court and was denied, under threat of arrest at gunpoint, the right to defend him. Mr. Fury alleges that he has studied law since October 2010 and does not advertise his services as an attorney in fact, and will only represent personal friends and loved ones. He says, as all of my clients, which is defined as paying clients, are elders of the community, I will have a written contract that outlines my pay and duties and responsibilities. It's acceptable for me to be called a private attorney general, sovereign citizen, a barrister, assistance of counsel, advocate, guardian ad litem, general guardian, conservator. I am knowledgeable of the law. I am knowledgeable of contract. Therefore, I am competent to represent myself and my person properly as well as others. The complaint also states that in order to become a lawyer in Nevada, a person needs to apply to the state bar of Nevada and pass the bar exam. The complaint alleges that since the Bar Association requires individuals who wish to practice law get a license and pay a fee, annual dues, they may be seen as in contempt of court for disobeying the ruling of the Supreme Court of the United States. In Schwer versus Board of Examiners, the Supreme Court held that formal membership in the Communist Party and an arrest recorded to relating to union activities cannot be the basis for completely excluding a person from the practice of law. The Supreme Court has indicated that liberty component of the 14th Amendment's due process clause includes some generalized due process rights to choose one's field of private employment, but a right which is nevertheless subject to reasonable government regulations. Okay, so we get into all that. U.S. Supreme Court. There you go. Mr. Fury's complaint fails to state a plausible claim for relief and is frivolous within the meaning of Section 1915E because it lacks an arguable basis in either in law or fact. These are the online internet claims that plays out in real life. Mr. Fury's complaint should be dismissed with prejudice because it is clear from the face of the complaint that the deficiencies cannot be cured by amendment. The court notes that Mr. Fury has previously brought various claims against various Nevada governmental entities and officers, including other Nevada judges, based on similar allegations as the complaint here. See Fury versus Las Vegas Metropolitan Police Department. Case number 2.17-CV-01558-APG-NJK 2017. U.S. District Court Andrew Gordon accepted U.S. Magistrate Judge Nancy Cope's report and recommendation that Mr. Fury's complaint be dismissed with prejudice in light of the frivolous and delusional nature of his claims. That's what the court is saying. I'm what? Antonio Fury? I'm what? I don't know what. Accordingly, it is ordered that Mr. Fury's application to proceed in form of paupers is granted. It is further ordered that the clerk of the court file the complaint. It is further ordered that Mr. Fury is permitted to maintain the action to its conclusion without the necessary prepayment of any additional fees, costs, or security. The order granting informal pauper status did not extend to the issuance of subpoenas at government expense. It is recommended that in light of the frivolous and delusional nature of Mr. Fury's claims, Mr. Fury's complaint be dismissed with prejudice. Notice. Failure to address the brief injection. Bam. So yours, you got dismissed with prejudice, meaning you can't even amend the complaint and get it right. It was so frivolous on its nature. It was frivolous. Damn, homie. You said, I don't know what? You said, I don't know what? It's always the ones who ain't never win a case, always wants to talk about someone who won their case. It's always the ones who've never won that wants to tell someone who has won that they don't know what they're talking about. You notice that, right? Now, let me go over let me see. Here we go. Please give it to me. Give me the case. I mean, he's got so many cases. Come on. I ain't got a lot of time now. Come on. Oh, man. All right, let's go ahead. Here we go. Antonio Luis Ferry. On July 3rd, 2017, Magistrate Judge Cole entered a report and recommendation that dismissed the complaint with prejudice because the plaintiff's allegations are frivolous and delusional. She also recommends his application to proceed in former properties be denied as moot. Antonio Ferry did not file an objection. Thus, I am not obligated to conduct a de novo review of the report and recommendation. It is ordered that their recommendation be accepted. The complaint is dismissed with prejudice, and the application to proceed in former properties is denied as mute. The clerk of court is instructed to close the case. It's another one on you. It's another one on you. It's another one on you. Lawful Patriot. You see? You getting spanked all around in court. Look at that right there. Oh, let me get that on recorded. Look. You getting spanked all across the board. Damn. He's getting spanked all across the board. FREIRE court cases. He's getting spanked all across the board. Frey versus Solomon. I think, I hope this is not the same case. We just went. Okay, yeah, this is the same one we just went over. Let's get to it. I mean, Spirit Bus. Oh, that's the one that I really want right there. Here's another one. Nah. That's the one, Spirit Bus. So I'm gonna go do the docket sheet. I'm gonna do the docket sheet. I'm gonna go do the docket sheet and go find more of his cases. But I just find it, hold on. I just find it very alarming. I just find it very alarming how he can actually say this about me, and he's lost every case. He's lost every case. Look at him.
Courtroom procedure. Trust. Okay. I'm not sure.
I keep telling everybody, prove your claim. Don't go into court naked like him. He knows that there's a Sesticade trust. We all do. So prove it. Now, the flip side is...
Well, why haven't you proved yours? And your former properties, you only making $1,000 a month, having trouble. Why aren't you living out of yours? Huh? Why don't you prove yours?
Tell them, yes, prosecutor, I know your government. Everybody knows your government. But for the record, prove that you're government.
But you've lost every single case. What's there to prove to you? What's there to prove to you? You've lost all your cases. This is how bad it is for him. Look. Individual has filed multiple pro se litigants in federal court, primary focus on alleged civil rights violations. There you go. That's one of the biggest ones right there. One of the biggest ones. And look at here, right here. So he's the plaintiff in this case. What does he do? Let's go. Here we go. He files a complaint against defendants. Application to proceed without paying. Antonio Luis Ferret, they never want to pay the filing fee. These sovereign citizens, they never want to pay the filing fee. That's a big one. Application right here. Notice of assignment. Notice of parties. Court order ADR program. So, order to show cause in order for joint status. Plaintiff shall respond to this order to show cause within 14 days of this order. Failure to timely respond. Now, guess what? Right here. Look. Would result in dismissal of the entire action without prejudice, or the court decline to exercise supplemental jurisdiction over the state law claims and the dismissal of any other claims. So look at here. Order on request to proceed. The request is granted. Request to vacate orders filed by Antonio Luis Ferret. New case order upon filing complaint. Minutes in chambers. Order dismissing the action. The court on April 26, 2023 issued an order to show cause why this action should not be dismissed for lack of prosecution. So you didn't even come through with it. On May 18th, plaintiff requested to vacate orders. However, he has failed to adequately respond to the order to show cause because he has not described how he has timely prosecuted the actions. The court orders the case dismissed without prejudice. You couldn't even respond to a court asking them, why should I not dismiss this case? And you couldn't even respond to that. But you got all the answers right here.
I know that there's a contract between us. I signed my social security card, my birth certificate, my driver's license. All this should be silly little.
Oh, God. Look at these people, man. Look at these people. Look at these people. Look at him. So he's lost the Sullivan case. If we go, let's go here. So he's lost the Sullivan case. He's lost the Las Vegas versus Metropolitan Police Department case. He's lost this other case. Fraud claim. He's lost the Ferry versus Spirit Bus. Look. He always loses. But yet, he's going to come online just like the rest of them. He's going to come online just like the rest of them with all the answers for you. So, I'm pretty sure that this case, here we go, right here. I think this case kind of sums up the space. Marcel Lamar Wood. Marcel James Lamar Wood versus the United States. Pro se plaintiff seeks declaratory and unspecified monetary relief arising from the United States' purported misappropriation of his estate. Uh-oh. Already? June 28, 2022, plaintiff filed a form complaint accompanied by an index of documents. In the complaint, plaintiff alleged that the United States was and is acting as the custodian of his estate because pursuant to the Sesti KV Act of 1666,
that there's a Sesticade trust. He knows that there's a Sesticade trust. He knows that there's a Sesticade trust. We all do. So prove it.
Okay. All right. Okay. We're going to prove it right now. Don't worry. Pursuant to the Sesti KV Act of 1666, It presumed that he was dead or abandons his estate. He further alleges that neither presumption is accurate. He is alive and has not abandoned his estate. He represents that to support his allegations, he is attached to his complaint evidence of the United States involvement over his estate and the name and registration number of the estate. Finally, without any further explanation of the nature of his claims or the jurisdictional basis for asserting his claims in this court, there you go right there. Because now the belief is the key. We have an estate. They set up a trust. Now, what's the legal and jurisdiction basis over the court has over his claims? They can never explain it. That's why the court said, without explaining, he requests a declaration that he is the entitlement holder of the estate. A declaration that he is alive and to be compensated the interest from the estate from the United States. Once again, chasing money through lawsuits. This is what they do. They chase money through lawsuits. Turning to the complaints appendix, some of the documents appear to set forth a philosophical foundation for plaintiff's claims. Not a claim that's based on law and fact, but philosophical, while others are in the form of estate planning documents apparently intended to support his claim. The court will not examine each of these documents in detail here, but instead presents a brief overview of their contents. The first document, titled Notice and Warning to Utility Companies. The key allegation in this document is reference to the bankruptcy of the United States that purportedly occurred in 1933. Since House Joint Resolution Public Law 7310 was passed in 1933, we only had debt, because all the property and gold were seized by the government as collateral in the bankruptcy of the United States. The document also includes the following passage, presented without alteration. Every judge and every attorney in America, especially those who hold positions with several direct connections into the utilities company's bank accounts and acting as attorneys for the banks, most presumably in all other countries as well, since they all get their instructions from England, the same place that all banks get their instructions through the Comptroller of the Currency, headquarters in London. I've read that in a sovereign citizen document. It was dated like 2003. He's just quoting from what others said. He did not do any independent research to come to that conclusion. Each knowing the above and incorporated to be true, since they are well versed in the U.S. bankruptcy of 1933, and that America still remains to date in a state of emergency and operates under English law, though that also is supposed to be a well-kept secret. Since there is no money, it further means that since there is no money, America's signatures are used as the credit to run this country. That in turn means that it is the American people whom are the creditors, not the debtors, as the banks and utilities companies would like everyone to believe. The second document is a schedule of fees through which plaintiff purports to establish specific monetary penalties for various infractions related to the trust, which owns the copyright, trademark, and trade name, Marcel James Lamar Wood. Once again, you cannot unilaterally copyright your name. For example, the unsolicited interrogation of the trustee of the trust as that person's names or driver's license number is a 10,000 infraction. Here goes the fee schedule. Requiring a signature under threat, duress, or coercion, $1 million infraction. You would never get it cashed. The third document is the first will and testament of the grantor, in which plaintiff purports to provide identifying information of the estate that is the basis of his claims. I, Sheila Vandoria Mack, being a sound mind over the age of 50, as grantor of the private trust security estate Marcel James Lamar Wood, registration number, date of registration, do bless and do grant irrevocable power of attorney over said trust security to my son with his agents this 20th day of May. Right. In the next document, an affidavit of correction. Plaintiff asserts that he is correcting an error on his birth certificate because the name on the birth certificate is in all capital letters, which must be considered a fictitious name, whereas the proper form should be written Marcel James Lamar Wood. The next two documents are affidavits, one of which knowledge of facts, another of life, which appear to have the purpose of establishing respectively the truth of the assertions in the documents attached to the complaint, and that plaintiff is indeed alive. In the document that follows, plaintiff referenced the 60 KV Act of 1666, includes a passage attributed to its authority related to the circumstances of a person being alive under after having been presumed dead. Plaintiff then presents a declaration of trust, which identifies his name as a component of the trust corporate. The final document is the last will and testament of Marcel James Lamar Wood. Having considered all the plaintiff submissions and finding a response from defendant unnecessary, the court is prepared to adjudicate plaintiff's claim. They didn't even order the government to respond. All of the legal theory presented in support of plaintiff's claims is cryptic. The complaint has the hallmarks of a sovereign citizen suit. Well, there you go. You didn't need me to say it. You don't like when I say it, so I'm going to let the judge tell you.
You're rocking with the best.
He's too angry to get a clear understanding. Yep. Yes, sir. Yeah, yes, sir. I mean, if you want to, but I usually go by contracts. And yeah, we have official contract signed, and that does come with the terms of the agreement. What's the status of your case? Or what's the status of your situation? Our investigations, and then you get with the contract, of course, the payment terms, whether you need to get on a payment plan or not. It shows you the actions that we are going to take. When I say we, me and my team, if I got to reach out to the professionals, get a professional opinion, I would do that. If I got to reach out to this person, I would do that. The statutes, the rules, everything that supports our claim. So you'll have a 100%, like you won't be left in the dark of what's going on, basically what I'm trying to say. You'll know exactly the actions we take and why we taking, case laws and the statutes to support the actions we taking, and you'll get a realistic overview of your case and what we're going to do to argue, which that comes with the counseling session, because we got to get you prepared for court, the nuance of court, the understanding of court. You got to get caught up on the court rules and procedure. So you got to be ready to go. You got to be ready to go. Pro se pleadings are held to less stringent standards than formal pleadings drafted by lawyers and are to be liberally construed. However, the leniency afforded to a pro se litigant with respect to mere formalities does not relieve the burden to meet jurisdictional requirements. That's going to be what we go over right there. That's going to be it right there. So basically what I'm saying, whatever claim that you think you have, I'm going to look at your claim first. I'm going to analyze the claims that you think you have, because you may come to me thinking you have one claim, but there may be, that's not the best claim. This is the better claim, and here's why. Here's your claims. These are the roadblocks. Here's the claims I presented. These are the potential roadblocks. You see how the potential roadblocks are lesser over here than here? The fact that a plaintiff acted pro se and drafted his complaint may explain its ambiguities, but it does not excuse its failures, if such there be. In other words, a pro se plaintiff is not excused from his burden of proving. That's this is what we're relying on to prove your claim. Here's why. By a preponderance of evidence. That's the investigative. That's your record. That's your documents. That's where the investigative comes in. Because everything that we assert, we have to prove on the record. And what we assert has to be in line with the court rules and procedures. And cases cited has to be substantial law. That the court possesses jurisdiction. Whether court has subject matter jurisdiction to decide the merits of a case is a threshold matter. Without jurisdiction, the court cannot proceed at all in any case. Jurisdiction is the power to declare the law, and when it ceases to exist, the only function remaining to the court is that of announcing the fact and dismissing the cause. So, you have a claim. We can cite any claims that we want. We can go to court and say, yo, they owe us $50 billion. I'll be like, okay. They owe you $50 billion. The real question is, the claims that I'm raising, does the court even have jurisdiction over the claims that you get what I'm saying? Does the court even have jurisdiction to grant it? So whatever claims that you have, in other words, they have to be recognized as legal, valid claims, whether at law or in the gray area of equity. So there may be a statute, case law to support it, or it may be a statute, equity with a little case law principles there, court doctrine there, but you can't just unilaterally ask the judge to do something that's outside the scope of their jurisdiction, because they may not be authorized under law to even grant you the relief that you request. You get what I'm saying? So all claims and reliefs has to meet the court rules, procedures, and the requirements. The question of subject matter jurisdiction may be raised by a court on its own initiative at any stage in the litigation. So that means subject matter jurisdiction goes to the subject matter of the claim, meaning you actually have to state a claim upon which relief can be granted, because if you don't, the court may not have subject matter jurisdiction over the claims you're asserted. And if the judge lacks subject matter jurisdiction, that's where you see the Rule 12b-6 motions, or the motion for, motions to dismiss. The ability of the United States Court of Federal Claims is to entertain suits against the United States is limited. The United States as a sovereign is immune from suits save as it consents to be sued. Basically, you can only bring cases in which the United States agrees that, yeah, if we do this to you, you may be able to sue us in court. United States versus Sherwood, 1941 case. The waiver of immunity cannot be implied, but must be unequivocally expressed. This is why, like the IRS, they say, hey, if you feel like we made a mistake, you can either pay us the fine or you could sue us in tax court. Anytime when the government's saying, hey, you can sue us if you don't like, that's when they're consenting to be sued. The Tucker Act, the principal statute governing the jurisdiction of this court. So the Court of Federal Claims is governed under the Tucker Act. So in this case, I would look at, what claim are you trying to bring against the government? Cool. Does this claim fall under the Tucker Act statute? Because if it falls outside of it, then you have no claim in the Court of Federal Claims. This is why the Tucker Act is the principal statute governing the jurisdiction of this court. It waives sovereign immunity for claims against the United States that are founded upon the United States Constitution, a federal statute or regulation, or an express or implied contract with the United States. So if all these internet claims were true, then they would be able to prove his Cesti Key Act, birth certificate, estate under the Constitution, a federal statute or regulation, or an express or implied contract with the United States. 28 U.S.C. section 1491A1. However, the Tucker Act is merely a jurisdictional statute and does not create any substantive right enforceable against the United States for money damages, meaning the Tucker Act just grants the court jurisdiction to hear the claim. In order to actually sue the United States government for monetary damages, the statute that you're relying on must be a money mandating statute, meaning if any person violating this section entitled may be liable for damages up to this amount. You get what I'm saying? So the statute that you're actually, the jurisdiction is the Tucker Act. This saying, hey, Court of Federal Claims, I'm bringing this claim under the Tucker Act. This is under your jurisdiction. Cool. Now the actual damages, you have to point to a statute that says if the United States violate this, they may be liable for damages. That's why I say it's merely a jurisdictional statute and does not create any substantial right enforceable against the United States for money damages. United States versus Teston. Instead, substantive right must appear in another source of law, such as a money mandating constitutional provision, statute, or regulation has been violated or an express implied contract with the United States. Love Ladies Harbor Inc. versus United States. What I said. So they're saying the same thing. The Tucker Act is the jurisdictional. Now, the statute that you rely on, the regulation, the contract, implied or impressed, that must have the money mandating statute. To determine whether it has jurisdiction, the court discerns the true nature of the claim in the complaint and it's not constrained by the plaintiff's characterization of the claim. So basically they're saying is the substance of your claim, not what you, all that stuff that you're saying it's a trust estate, but the substance. So you're basically suing the government for interest in your estate that they created because they took all the gold in their place as collateral. That is the substance of the claim. There is no court in the United States of America that will entertain such claims. There's not even anything on the books that will grant anyone the right to recover from that premise. If the court finds that it lacks jurisdiction over a claim, see, you see that? So since Marcel's, the federal claim, since there's no statute, no law, no act of Congress that actually states that private individuals have trust in their names. And if you don't give the private individuals, once they reach a certain age, their interest from the trust, the government may be liable in court. Since there's nothing on the books that he could point to that what he said actually took place, that the government consented, that the government set up a trust, that the government consented to being sued if they don't grant him the interest in the trust, since he can't point to one of those, then the Court of Federal Claims has lost their jurisdiction. This is why it says if the court finds that it lacks jurisdiction over a claim, Rule 12H3 of the Rules of the United States Court of Federal Claims requires that the court dismiss the claim because there's nothing that they can't even grant him the relief. And if you're in the Court of Federal Claims, that's why when I say court is 98% rules and procedure, the other two are the facts and circumstances of the case. This is what I mean. See, all this right here is rules and procedure. This sets the tone for whether the judge can even entertain your claim or whether you stated the claim. It's going to, right here, this is all rules and procedure. Now, this is the facts of his case. The analysts, now they're analyzing the facts under the rules of procedure. This is why the rules of procedures came first. Now they're going to analyze the facts. Plaintiff's claims as best the court can discern, because they're never really, they're always unintelligible. It's premised on his interpretation of his status as a person who is alive, who may have been presumed dead. His contentions that his birth certificate does not accurately reflect his existence, and his assertion that his estate, Marcel James Lamar Wood, requires him to be compensated by the United States. That is 99.99% of all social media online foundational beliefs and claims in these spaces. Right there. It starts right there. That's the first thing you hear when you're a newbie in these spaces. That's the first thing you hear. That is the first thing you're going to go by. That's the first thing they're going to cram down your throats. That's going to be the very first thing. What product of yours would you recommend purchasing to get knowledgeable about a car loan to eventually take in court? How about you? Yeah, how about you do? Because I'm gonna need more context. Are you trying to sue? Are you trying to sue? Are you trying to, are you current? Are you in default? Are you trying to, because you're trying to go to court? Yes. That would be the litigation services. That covers the initial investigation into your claims. That covers actual preparing the claim, drafting the claim, making sure the court rules and procedures are adhered to in your jurisdiction. That comes with, that's the whole thing. Discovery, if it gets there, production, request, like discovery stage, deals with the in-court proceedings there too. Preferably if you could do Zoom, that'd be better because I could be in your ear at the same time. But I think you're talking about taking them into court. Now, if you want to take them into court, that's one of my specialties. But I will say this. Whatever claims that we're trying to do, because I don't want you to think that you could just go run a document into court, because court is a thing that happens in stages. So the first thing would be us bringing the claim. Now, if you're if you're in current, that is actually great. If you're in default right now, it's not the end of the world, but our claims will actually have to be structured to compensate for that. But I think you're talking about litigation, because like if you're stepping into the court, it goes with drafting a complaint, drafting a motion, finding the errors, substantial law to support it, rules of procedure, et cetera, et cetera, et cetera. So that's an intricate process that I put that together from scratch based on the records, the facts, and the evidence that I asked you to provide. Of course, I'm going to need the contract. I'm gonna need all the payments that you've made. I'm gonna need any correspondence. If you sent anything to them, I'm gonna need that. If they responded to you, I'm gonna need that. I'm gonna need anything and all correspondence, documentations, and evidence so I can, build the complaint from the record. There's no actual template. There's no actual template that that can be used to actually build that. I have to build it off the evidence and the records that's provided by you. So we'll most definitely be able to get that taken care of. Now, it says right here, so these are sovereign citizen type arguments where such plaintiffs attempt to convince courts that their status as sovereign citizens differs from the status of the fictional individuals identified by their birth certificates. C. Davis versus United States. Often, a sovereign citizen plaintiff will argue that his or her birth certificate and or documents evidences a trust that he or she has the right to collect the funds in that trust from the United States. Davenport versus United States, 2017, stating that proponents of the sovereign citizen theory allege that their security interest results in the creation of an individual trust account, an attempt to claim the funds in that account by suing the United States. Rivera versus United States, 2012, noted that a sovereign citizen may assert that he or she is sovereign, not a United States citizen, and therefore is entitled to obtain certain funds under the theory known as redemption. As in this suit, a sovereign citizen may reference House Joint Resolution 192 of 1933 as a legal basis for his redemption claim. See Rivera. One thing that you won't get with me is any of this. One thing that you won't get with me is I don't owe the debt anymore. Oh, I don't do this. Oh, no, the government is responsible for the debt. Oh, no, securitization kills the debt. Oh, no, you didn't loan me money. You loaned me credit. You won't get any of those arguments from me. Oh, we don't run away from the fact that you're in a contract, that you signed a contract, that you told them you're going to pay. Oh, we don't run away from that fact. As a matter of fact, that's the first thing that we recognize. Because there's no getting around your name on the application, your name on the contract, your name on none of that. There's no getting around it. But that's not even the premise. See, the contract itself, see, I don't like to deny the contract or the existence of it because the contract itself is evidence. So what we're going to do, I'm going to take your contract. Trying to sue in current. Oh, you are in the best position. Hold on, let's shout out to current and plaintiff. Shout out.
You're rocking with the best.
Shout out. Yo. Yes, sir. Send that email. Oh, yes, sir. But you don't know how much I love like current and plaintiff. Now, when I draft a complaint, I bring all the merits, all the elements, everything in. Now you get set you. You get set you because you're not the defendant, and I don't have to respond to what they're saying. They got to respond to us now. What company are you with? The sovereign citizen redemption theory typically includes the following elements. Many sovereign citizens believe that the government began issuing legal tender in 1933. All citizens were pledged as collateral for the national debt, resulting from the loss of value from the gold standard. All sovereign citizens therefore have two identities, the real private individual and a fictional public person. Refusing to be used as collateral can hypothetically result in access to a trust fund held in the fictional person's name at the U.S. Treasury. Jessica K. Phillips. Not all pro se litigants are created equally. Examining the need for new pro se litigant classifications through the lens of sovereign citizen movement. This is Georgetown, 2016. Sovereign citizens also sometimes reference the Sesty Key v. Act of 1666 and Sesty Key v. Trust as support for their arguments in court. United States versus Nissen, discussing a pro se criminal's defendant sovereign citizen arguments that relied on the Sesty Key v. Act of 1666 to assert that the court had no power over him. Wow, that's crazy. That's crazy. Damn. Here, similarly, plaintiff relies on the Sesty Key v. Act of 1666 in both the form complaint and its appendix to assert that because he has been presumed dead, the United States has become the custodian over his estate and now owes him interest of the estate. Finally, the court notes that sovereign citizen plaintiffs often make a distinction between their names written in all capital letters and this same names written with just the initial letters capitalized. Bryant versus Washington Mutual Bank, 2007. This is actually one of the landmark sovereign citizen case with court and the vapor money theory and the bills of exchange because it came at the time when he was at the height of the recession. Noted that the sovereign citizen theory typically asserts that the name of the fictitious entity is the real person's names in all capital letters, which apparently explains why names are commonly written in all capital letters on birth certificates, driver's licenses, and other government documents. Footnote, a Sesty Key v. is the person whose life measures the duration of a trust, gift, estate, or insurance contracts. And you notice how they use the Black's Law Dictionary to give you context, but they use the 11th edition. Foreign law is not among the money mandating statutes of law that fall within the ambit of the Tucker's waiver of sovereign immunity. So y'all keep talking about you're foreign, you're not a U.S. citizen, you're foreign to it. You actually waive some of your rights. So the law of Panama, a foreign country, cannot act as a waiver of sovereign immunity that was required for Tucker Act jurisdiction of this court. Similarly, the Sesty Key v. Act of 1666 and English law, that's foreign law, cannot support Tucker Act jurisdiction for a claim of this court. So the mere fact that he cited the Sesty Key v. Act, which is oh, how did I fucking know? How did I know? I literally have a full-blown on report on them. I literally have a full-blown on report of them. They was part of my major investigations. Oh, you already know how they operate. That's cool. CarMax. How did I figure? I was like, I mean, they're big companies. So I understand that. Sovereign citizens typically believe that they use the proper capitalization of their names. They can redeem the funds held by the United States in secret individual trust accounts for each citizen. Here, too, plaintiff states that his proper name is not to be written in all capital letters as it was written on his birth certificate, and he is entitled to the interest of the estate held by the United States. See, what you won't get is any of this crap. In short, the legal fiction presented by the plaintiff in the complaint is not based in law, but in fantasies of the sovereign citizen movement. Remember, your claims has to be based in law or fact, and they have to be plausible on its face. You have to state a claim upon which relief can be granted, which is plausible on its face, not merely possible the defendants committed the act's claim, but it's plausible that they did. So the needle has to move from possible to plausible, saying, you know what? It's most likely that this did happen like this. Yeah, you got to respond to this complaint. It's most likely that it did. There's no jurisdiction in this court for fictitious claims. See Boeing Company versus United States, stated that allegations of subject matter jurisdiction to suffice must satisfy a relatively low standard, but also noting that essentially fictitious claims do not meet the standard. Quoted Shapiris versus McManus. Like other monetary claims of sovereign citizens the court has considered, plaintiff's claim must be dismissed for lack of jurisdiction. You notice how they didn't dismiss the claim for its being fictitious They dismissed it under the rules of procedure because the claims are fictitious, because the claims don't fall within the Tucker Act jurisdiction. The court don't even have jurisdiction to even entertain the claims, let alone grant him the relief requested, because there's no law on the American books that even has relief for these types of claims. So the court don't even have the jurisdiction to even entertain the claim. That's why the court is dismissing it for lack of jurisdiction. See, Ammon dismisses sovereign citizen redemption claims sua sponte for lack of jurisdiction. Sua sponte means right there on the judge's own accord. Didn't even, soon as they got the complaint, read it, dismiss it. Didn't even have the other side respond. Dismisses sua sponte sovereign citizen claim founded on fictitious trust fund accounts with the United States Department of Treasury for lack of jurisdiction. The clerk office is directed to dismiss the complaint for lack of jurisdiction without prejudice. Further, the court certifies pursuant to 28 U.S.C. 1915 that any appeal from this order will not be taken in good faith because, as alleged by plaintiff, the claim is clearly beyond the jurisdiction of the court. The claim is beyond the jurisdiction. There's nothing there that the court can even grant him relief. And this is why it's dismissed. So that's one of the so let me just tell you what that meant. So with these claims online, since the courts don't, like, they don't even have the authority to grant relief that doesn't the statutes, the law, courts of equity, there's nothing there for them to give you, because there's nothing that the claims arise from with these people that they can find on the Constitution, they can find in a statute, regulation, state law. So your laws, the laws of your state, the laws, federal laws, whatever, those are where kind of you're going to bring your claims, like in a auto context. We got to look at the laws that governs these transactions. And we got to find our claims from there based on the facts and the evidence. See, the contract itself is going to be used as evidence. That's why I don't ever dispute whether you signed the contract, what ink's in it. No, the contract is evidence. And let me see if I can because the actual elements of the claim, let me see. Okay. Let me see if this is it right here. So this right here, let me see if I can. This is actually one of the things that we put together for a member of my group, and they actually about to get their ass handed to them on a silver platter. Let's see if I could do it like this. Let me see if I could do it. Can I do it like this? Go. All right, let me do it like, let me see. So evidence. The evidence shows that CarMax. So this is what's sent to them, letting them know this is what's coming. So this is from the report I did. Evidence shows that the CarMax securitized my installment contracts, part of his financing program. Me and CarMax has already received the present compensation for a substantial portion of my payment stream. According to their quarterly filings in their inaugural non-prime securitized $625 million. And the transaction describes sales, rather origination, plain terms, took on the liability to investors for the money raised and kept my loan on the books as an asset. Accounting rules require the treatment. See, this is what's sent to them. When it gets to court, this is going to be argued under the court rules and procedure. And I got them on. These are all. So basically letting them know all these broke down. That's why I like the contract, because I take the contract and I break down. CarMax retained between 7,000 this finance through extended service program, estimated 30-50% ESP premium. I finance roughly 7 as a profit. Dealer commit. That's why I take the contract and I break the numbers down. So basically, this is showing how the numbers on the contract are not the numbers that they economically say you owe. So this is why I did. This is part of the investigation. Now, failed to notify me. Bam. As you can see, Nebraska's cold because out of Nebraska brought into bankruptcy implications. If this were to go there, how they would still have a claim. I brought up, how this is supposed to be reported for the tax purposes. So this is the investigation. Exhibit E, Exhibit D, notes, right there, all of that. Never, and I love it. And this just put them on notice how we coming. See what I'm saying? Nevada statute, see? And then I give them, right. Even if CarMax is a licensed sales finance company, the person remains that charge more disclosed on the rate via hidden fees and not allowed. The Nebraska Supreme Court has clearly said right there. And then I got case law to support them. See, I'm letting them know this is how we coming. If you want to do this now, yeah. We could do this now, we could do this later. So it's letting them know, this is how it's. Yep. All that broke all their accounting, all of them down. All this is everything that we come. Everything. Exhibit A, Exhibit B, Exhibit Z, in the footnotes. These are the footnotes. Let me know. This is the evidence. This is what I researched against you. They're public disclosures, Nebraska law, case law, their accounting standards. What happens is a bankruptcy, other cases. You see, a thorough investigation. Thorough investigation. That's what I say. I already investigated CarMax. Yeah, see what TikTok did? Look at TikTok, y'all. Hate speech and hateful behavior. I wasn't even being hateful. Do not spread hate. He was saying this. Let's see this shit. Appeal. I gotta appeal that. Should I put something else? I was reviewing content that was made about me. The offensive remarks were against me. I wasn't promoting it, was showing how I was talked about. I was showing what was said. I guess. Look. And all I was doing was that's all I was doing, just reviewing what he was saying, going to break his cases down. He said, "What's up with all the cussing?" That's what I'm saying. I don't know where they thought I was platforming them, but I wasn't platforming them. I was just reviewing what he was saying and breaking it down. So yeah, so that's what it is, y'all. Yeah, but if it goes to CarMax, man, it's CarMax, Santander, Westlake, Credit Acceptance, all of them, all the major players, mortgages too, UWM, Loan Depot, Fannie Mae, Ginnie Mae, all of them. I will be checking back in. The brother has been in ICU with his wife. I hope she pulls through. That's crazy. I hope she pulls through because it looks like the yeah, looks like I don't want to speak worse, but it's looking kind of oof. I don't even want to really, but it is looking kind of, I don't know, man. It came out the blue. It's not looking, it's dire need, right? It's a dire situation right now. But it's all good though. It's all good. I'm staying in contact and just try to get this date for the Fannie Mae work with mortgages to give his presentation. I am been in contact with him. I'm going to be calling him back tomorrow just to get a status update on her and where we can get the situation for the situation, the demonstration lithiated. But yeah, other, if you have any other inquiries or things like that in that nature, I always review cases, I review documents, I review filings. And if I don't have the answer, I know people who do. It's nothing but a text or phone call away, which makes it even more special. And that's part of the access you get with my services. When I'm done, it goes through a security checks, compliance checks, and then I get the professionals to look over it. Hey, what you think? And it is. But then I need to tighten up or anything. It looks good to me. What you think? Boom, boom, boom. Once they come back with their checks, it's like, nah, this is sufficient. And then we're ready to go. But it's not just the drafting. It's I got to get you prepared for court as well. So I got to get you prepared on the court rules and procedures and stages. I can't just throw 50,000 rules at you. What's most important for you to understand right now at this stage in the proceeding? Okay, these are the 4 set of rules we're going to focus on right now. Don't worry about the next. When we get to the next stage, we're going to, when it gets there, because remember, there's time in between you serving, filing, responding to motions. There's time in between. So when you actually get the complaint ready to file, you actually get your checklist. Hey, study, focus on these 4 rules right here. These are the elements, because long as you know that, so basically you already know what's going on in your case. You know what you signed, you know what's going on. And then I bring in the court rules, procedure, case law to support it. So that's going to give you more confidence because now you got the legal way of saying it. You can't just say, oh, this happened, they did this. You got the legal way of presenting it. And then it's not going to be easy to forget because you already know the underlying elements of your case. You already know what took place. You already know the contract you signed. You already know what you put down. You're already familiar with your own transaction. So now we take here's the violations in layman's terms, break it down to you in layman's terms so you can understand, oh yeah, I get that track. Okay, so this is what this means now. So you see the legal technical terms. Now this is what it means. So like, oh, okay. So now you can tie 2 and 2 back together because now you get the technical meanings and what it means in layman's terms. So yeah, and then we just take it from there. But what you're not going to get is immediate dismissal. You're not going to get immediate motion to dismiss. I've already researched a lot of cases with these finance companies, how they're going to respond, what they're going to do. But one thing that they're not going to be prepared for is, well, he's not in default. So we can't even raise that regardless he's in breach of the contract because you're not in breach. So they can't even go down that lane. Now they have to respond to things that they've already admitted, responded to things that they know how they do. So they can't take a different position now they're in court in which they already disclosed.
So they're stuck in their position. They can't say nothing different. Oh, most definitely. Yes, sir. We go big or we go home. You have been listening to the New Culture Empire. I will catch you on the next one.
Rolling the dice, we won cause we plan. All the things that they teach, don't know how to stand. On my wrist like a stage, they can't glance. You look like you wanna let go of stress. What's up? I thought so. Oh, I am the blueprint. If not, why you copy me, fam? What's up? I thought so. Okay, I cannot help that they copy. Hey, I am that dad, call me Poppy. Yo, they wish they created the set. Yes, they on my D like a jockey. When it comes to the print, I'm the blue. Who? Every complaint, draft is smooth. Supreme Elite team be the ones. Yo, I created my own school. Facts. I came from the trenches. I came from riding them benches. To proving my case with exhibits. My craft is exquisite. I find where they hiding them digits. The cancer that's not in remission. Hey, please pay attention. You can't recreate the five lenses. You can't duplicate what is written. You either gonna pay the tuition or pay for assistances. Or pay the mistakes when you case it, dismiss them. I come with everything that's under the kitchen. See, I haven't slept in a week. They scared while I'm willing to compete. These scammers are devils and I keep them under my feet. Hey, they saying they win, I never take their prescription. They never coming from the plaintiff's position. I am the blueprint, blatant admission. Check it, when I talk classes in session. Professionals, even the tacos respect it. Show me a win, that's not a rejection. Tell me the truth without all the stretching. These gurus are boring and it's stretching. These students are dumb, desperate depression. Set you, yeah, I'm done with this lesson. Came from the streets, still I'm a step up. Run it up, running bands. They scared of my team, they know who I am. They rolling the dice, we win cause we plan. On the things that they teach, don't know how to stand. On my wrist like a stage, they can't glance. You look like you wanna let go of stress. I thought so. Oh, I am the blueprint, if not, why you copy me, fam? What's up? I thought so. Okay. New culture, he running this shit. Like he came with a gun in this bitch. And he double up wins back to back. Like he ain't even done with this shit. Come to court like a dog off the leash. Dismantle the evidence, break down their claims, and he start from the top of the sheet right here. Whenever he taught, they retreat. He's a lead with his team, they supreme. He brings reality out of drink. Okay, they can't help but watch from the clouds. They trying his awards and the memes. Alibi with the feds. You fuck with alibi, you be in the feds. Lawful levy, still a rookie. Can't stand on this shit that they saying. Hey, he beat his case, he beat CAC to submission, stipulated the disposition. Westlake, he tried to give a break. Attention they didn't wanna pay. Made them max sit, they on case. Get the fuck out his face. The new culture ain't wanna play. The new culture running this shit. The new culture with debate. Anyone who think they running this shit, he take your docs and expose that shit. Gon' be acting like you never sold that shit. They copy his drip like he sold that shit. Ain't no guessing with him, gotta know that shit. Hey, you gotta know that shit. Credit acceptance, I be Westlake. Whatever I'm serving, they eat the plate. They don't watch me loud, but they watch from the clouds. They copy my style, but can't figure me out. The 5 mixes, I created that. You can't duplicate from an AI chat. He thinking things that they can't comprehend and teach what people did not know exist. Run it up, running band. They scared of my team, they know who I am. They rolling the dice, we win cause we plan. The things that they teach, don't know how to stand. On my wrist like a stage, they can't glance. You look like you wanna let go of stress. I thought so. Okay, I'm the blueprint, if not, why you copy me, fam? What's up? I thought so. Okay. I thought so. Okay. I thought so. Okay.
You're rocking with the best. You're rocking with the best. You're rocking with the best.